Judicial Department. So in Article 8 of the 1987 Constitution, the Judicial Department. The Judicial Department in Section 1, judicial power shall be vested in one the section number 1, the judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch of instrumentality of the government. Again, Section number 1, the judicial power shall be vested in one Supreme Court lower courts as may be established by law. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable and to determine whether or not there has been a grave abuse of discretion amounting to supremacy. The doctrine of judiciary to annul the acts of either the legislative or the executive branches of government or of both when not conformable to the fundamental law. The inherent powers of a court, the inherent conformable with law and justice includes the right to reserve itself, especially when, in its honest opinion, it has committed an error or mistake in judgment, in that to adhere to its decision will cause injustice to a party litigant. The court is not precluded from examining its own ruling and rectifying errors of judgment if blind and stubborn adherence to res judicata would involve the sacrifice of justice and or in immediate danger of sustaining an injury as a result of the act complained of. Requisites to have a locus standi to have standing. One must show that he has suffered some actual or threatened injury as a result of allegedly illegal conduct of the government. The injury is family traceable to the challenged action and the injury is likely to be redressed by favorable action. The principle of transcendental importance, the doctrine is determined by character of the funds of other assets involved in the case, the presence of a clear case of disregard of constitutional or statutory prohibition by the public respondent agency of instrumentality of the government, and the lack of any other party with a more direct and specific interest in raising the question being raised. Rule on standing in a matter of procedure, hence, can be relaxed when the proceeding involves the assertion of a public right. The mere fact that the petitioner is a citizen satisfies the requirement of the personal interest. Thus, the privatization power plans in a manner that ensures the reliability and affordability of electricity in our of paramount public interest, in which the court held the petitioner possesses the requisite legal standing to file the case. When the issue concerns a public right, it is sufficient that the petitioner is a citizen and has an interest in the execution of the laws. The locus standi in cases involving taxes. A taxpayer need not be a party to the contract to challenge its validity. If taxes are involved, people have a right to question contract entered into by the government. Further, the issue raised in the petition do not refer to the wisdom, but to the legality of the acts complained of. Thus, we find the instant controversy within the ambit of judicial review. Besides, even if the issue is legal in nature, it would still come within our powers of review under the expanded jurisdiction conferred upon us by Section 1 in Article 8 of the Constitution, which includes the authority to determine whether grave abuse of discretion amounting to excess or lack of jurisdiction any branch of instrumentality of the government. Local standing in environmental cases. In our jurisdiction, local standing in environmental cases has been given more liberalized approach. Recently, the court passed the landmark rules on procedure for environmental cases, which allow for a citizen suit and permit any Filipino citizens as steward of nature to file an action before our courts for the violations of our environmental laws. Thus, the need to give the resident marine mammals legal standing has been eliminated, and it is noting that the stewards are joined as real parties in the petition, in not just in representation of the name species. The filing of the petition for the issuance of a writ of kalikasan does not require that a petitioner be directly affected by an environmental disaster. The rule clearly allows juridical persons to file the petition of persons whose constitutional right to be a balance is violated or threatened with violation. The scope of judicial review: the courts have the power to pass upon the validity of the constitutionality of laws enacted by the legislature and that other bodies of the government under the doctrine of checks and balances. The lower courts are likewise vested with the power of judicial review, subject, however, the appellate jurisdiction of the higher courts. The constitutional challenges: when a law is passed, the court awaits an actual case that clearly raises adversarial possessions in their proper context before considering a prayer to declare it is an unconstitutional. However, in a case where the law passed incorporates the exact clause already declared as unconstitutional without any perceived substantial change in the circumstances, the court ruled that there is a necessity to decide the constitutional issue involved. Thus, when a law or provision of law is null because it is inconsistent with the Constitution, the nullity cannot be cured by reincorporation or reenactment of the same or similar law of provision. A law or provision of law that was already declared unconstitutional remains as such unless circumstances have so changed as to the warrant of reverse conclusion. The official act may be subject of judicial review, provided that the matter is not raised collaterally. The requisites before our law cannot be declared partially unconstitutional. The legislature must be willing to retain valid portion or separately clause, and the valid portion can stand independently as the principle of stare decisis. The principle of stare decisis. The principle of stare decisis deem or of imperative authority, controlling the decisions of life cases in the same court and in lower courts within the same jurisdiction, until the decision of the question is reversed and overruled by a court of competent authority. The court, as the highest court of the land, may be guided, but it is not controlled by the president. Thus, the court, especially with the new membership, is not obliged to follow blindly a decision that is determined after re-examinations to which is invalidating a law or executive act that is found to be contrary to the constitution validity of the law that results from the mere dismissal of a case challenging the validity of the law, and symbolic, which aims to educate the bench and bar as to the controlling principles and concepts of matters of health and restraint upon the future. The power of judicial review in impeachment proceedings includes the power of review over justifiable issues in impeachment proceedings. The judicial review of the Supreme Court on findings of facts of administrative tribunals and trial courts. Generally, the Supreme Court will not disturb the findings of the facts of administrative tribunals in the trial courts. However, the Supreme Court may review findings of facts of the lower courts under the following exceptions. Number 1, when the conclusions of finding grounded entirely on the speculation, surmises, and conjectures. Number 2, when the inference made is manifestly mistaken, absurd, or impossible. The doctrine of ripeness of judicial review. The basic principles of ripeness is that the judicial machinery should be conserved for problems which are real and present and imminent, and should not be squandered on problems which are future, imaginary, or remote. An issue is normally ripe for judicial determination when the interests of the plaintiff are, in fact, subjected to or imminently threatened with substantial injury. The political question. Concept of political question. Those questions which, under the Constitution, are to be decided by the people in their sovereign capacity, or in regard to which full discretionary authority has been delegated to the legislative or executive branch of organization of the government. The effect of expanded the definition of judicial power on the political question doctrine. The effect of the expanded definition of the the effect of the expanded definition of judicial power of the political question doctrine. The 1987 Constitution expands the concept of the judicial review. Under the expanded definition, the court cannot be agree that the issue involved is a political question beyond the jurisdiction of the court to review. When the grant of power is qualified, conditional, or subject to limitations, the issue of whether the prescribed conditions have been met or the limitations respected is justiciable, the problem being one of legality or validity, not its wisdom. Moreover, the jurisdiction to delimit constitutional boundaries has been given to the Supreme Court. When political questions are involved, the Constitution limits the delimitation as to questions are involved. The Constitution limits the delimitation as to whether or not there has been a grave abuse of this, amounting a lack of excess of jurisdiction on the part of the official whose action is being questioned. The moot questions. Concept of moot. Questions on which the judgment cannot have any practical legal effect or in the nature of things cannot be enforced. Moot in academic. It is moot in academic when it ceases to present justiciable controversy by virtue of supervening acts of that a declaration thereon would be of no practical use of or values. Courts' actions over moot in academic cases. Generally, courts should not decline jurisdiction of such cases or dismiss or in ground of mootness, except wherein this is a grave violation of the Constitution. This is the exceptional character of the situation in the paramount public interest is involved. When the constitutional issue raised requires formulation of controlling principles to guide the bench, the bar in the public, and the case is capable of repetition yet invading review. The court finds it appropriate to abstain from passing upon the merits of this case where legal relief is no longer needed, no called for the supervening conviction of CJ has rendered the present petition moot and academic. The actual controversy is the antithesis of mootness. Judicial power presupposes actual controversies, the very antithesis of mootness in the absence of the actual justice controversies or disputes. The courts generally opts to refrain from deciding moot issues where there is no more live subject of controversy. The court ceases to have reason to render any ruling of or make any pronouncements. The operative fact doctrine. Defined under this doctrine, the law is recognized as unconstitutional, but the effects of the constitutional law prior to its declaration of nullity may be left undisturbed as a matter of equity or play. It is a rule equity. In another case, the court held that no return the amounts received to respective taxing authorities would certainly impose a heavy and possibly crippling financial burden upon them who merely and presumably in good faith complied with the legislative fiat subject of this case. Hence, the doctrine of operative fact shall be applied. The vocation of this doctrine is an admission that the law is unconstitutional. Further, as an exception to the general rule, the doctrine only applies as a matter of equity and fair play. The applicability on Exercise Acts, the operative fact doctrine also applies to executive acts subsequently declared as invalid. A decision made by the President or the administrative agencies has to be compiled with because it has the force and effect of law. The term executive act is broad enough to encompass the decisions of administrative bodies and agencies under the executive department, which are subsequently revoked by the agency in the question of nullified by the court. The doctrine of relative constitutionality, a statute valid at one time may become void at another time because of altered circumstances. The constitutionality of a statute cannot, again, doctrine of relative constitutionality. A statute valid at one time may become void at another time because of altered circumstances. The constitutionality of a statute cannot, in every instance, be determined by a mere comparison of its provisions with applicable provisions of the Constitution, since the statute may be constitutionally valid as applied to one set of facts are invalid in its application to another. Thus, if a statute in its practical operation becomes arbitrary or confiscatory, its validity, even though affirmed by a former adjudication, is open to inquiry and investigation in the light of changed conditions. Section number 2. The Congress shall have the power to define, prescribe, and apportion the jurisdiction of the various courts, but may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5 hereof. No law shall be passed reorganizing the judiciary when that undermines the security of tenure of its members. Section number 3. The judiciary shall enjoy fiscal autonomy. Appropriation for the judiciary may not be reduced by the legislature below the amount appropriate for the previous year, and after approval shall be automatically and regularly released. The constitutional guarantee of fiscal autonomy contemplates a guarantee of full flexibility to allocate and utilize resources with the wisdom and dispatch that the needs of require. It recognizes the power and authority to deny assets and collect fees, fixed rates of compensation not exceeding the highest rates authorized by law for compensation in pay plans for the government, and allocate the disbursed sums as may provided by law or prescribed by its the course of discharge of functions. In section number 4, number 1, the Supreme Court shall be composed of a Chief Justice. The Supreme Court shall be composed of a Chief Justice and 14 Associate Justice. It may sit in bank or in its discretion in division of 3, 5 of 7 members. Any vacancy shall be filed within 90 days from the occurrence thereof. All cases involving the constitutionality of the treaty, international or executive agreement or law, which shall be heard by the Supreme Court in bank, and all other cases which under the rules of court are required to be heard bank, including those involving the constitutionality.